Good evening. My name is Karen Harding. I'm a lawyer from Auckland, New Zealand, and I'm currently counsel for 30 plaintiffs who are Indonesian foreign fishermen who worked in New Zealand on work permits between December 2007 through until the latest in October 2011. They were not paid the New Zealand minimum wage and were effectively forced labour, which equates to human trafficking, and they lived life akin to being slaves at sea on vessels owned by the Sajo Oyang Corporation on vessels Oyang 77 and Oyang 70, which sank, where 6 people died, in New Zealand. Now, I'm seeking justice for them, and in relation to that, we filed applications for unpaid wages under Section 256 of the Fisheries Act 1996. We started the litigation on 11 February 2015 at the Christchurch District Court, when we filed the notices in respect of 24 people at that time. And by the time we had our first hearing on the application on the 16th of April 2015, we had 26 plaintiffs. Then in July we had 27, and by July in 2016 we had 30 plaintiffs. Now, from that, because one of the vessels sank, they were not able to get an in-rem claim over the ship, and they also had trouble getting a lawyer, and they just didn't get paid. And so I took the opportunity to file proceedings for those crew members over the Oyang 75 vessel that was forfeited for fishing crimes. Beautiful vessel, worth about $8 million US, that was fishing in New Zealand, was involved in serious Fisheries Act offences and was confiscated under the Fisheries Act for being involved in crime. And then there's legislation under Section 256 of the Fisheries Act that says that you can make a claim for unpaid wages over forfeited property. And we submitted that Oyang 75, being a vessel that was used in the Fisheries Act offences and being forfeited, was property, and it was also forfeited, so it was forfeited property. We also have the unpaid wages claims. We made a claim under Section 256 round brackets 1 round brackets little c over Oyang 75 in respect of the crew from Oyang 70 that sank, and also in respect of other crew members from Oyang 77. We also claimed over Oyang 77, which was also forfeited. It's a vessel worth about $1.5 million New Zealand. It was also involved in very serious crimes. My clients have described it as a floating rust bucket. It was very unpleasant to work on that ship. And that was also involved in serious crimes and forfeited. However, the majority of my clients did work on Oyang 77, and that vessel's not enough to pay out their wages, because also out of the vessel would also have to be paid the costs of the criminal prosecution for investigating the crimes. That means all the Crown Solicitor's costs, or the costs of the Ministry of Primary Industries, which is our fisheries department in New Zealand, cost, and also there was hundreds and hundreds of thousands of dollars of fines imposed on the captains of the Oyang 77 and also the Oyang 75 and other people on the vessel, being Korean officers involved in these offences, and those fines have never been paid. And the Crown wants to recover the costs of the prosecution, the costs of investigating the crime, and the fines out of the vessels as well. So that would be even more hundreds of thousands of dollars. So it wouldn't be enough to pay out the wages. Collectively, there's somewhere between $4 to $6 million of wages outstanding. They were paid such a pittance that at the highest, if they actually got what they were supposed to get paid, that would have been $200 a month US for most people, up to $270 for the rare few that were on the higher pay of $270 a month for working 20 hours a day, on call 7 days a week, sleeping over on a vessel in abject conditions, which is just terrible conditions, with fleas in your food, cockroaches and mice running around your room. It's cold, it's wet, you're having to all bath together in one big bathtub because there's no individual showers, one toilet between all of them, and being abused. Some were raped, they were sexually harassed, there was a culture of sexual abuse, physical assaults, verbal abuse, racism, and very unsavoury things that happened that really damaged New Zealand's international reputation, bringing in forced labour to New Zealand's waters in a grand scale, because the Sajo Oyang Corporation operated a fleet of vessels. So we have the 3 vessels here in particular, one that sank where people actually died, suffering, getting fish, and what would probably have been a crime because it was overfishing and they didn't cut the net and it all sank. and then the other fishing crimes that they did. And we're also making a claim they should be paid for sleepovers, because if you're going to work people 7 days a week for 2 years without a single day off, treating them terribly like they're slaves, you should pay for every single minute they're on that ship and every single minute of that bad treatment, because that's work. They're living and working in poverty, in disgusting conditions, as slave labour, and the thing that we object to most, well, I do as their counsel, is that happened here in New Zealand. So that's what I've done. I've filed an extensive amount of paperwork with affidavits, supporting evidence and other things at the Christchurch District Court when we filed the claims back in April 2015. Now, since then, the case has rattled on through to the High Court at Christchurch on an appeal, then through into the Court of Appeal on an appeal, all related to Section 256 subsection 1 of the Fisheries Act, which relates to the interpretation section over who can apply over the vessels for unpaid wages and over what vessel. And the High Court was very helpful to us, and they said yes, you could apply over Oyang 75 even if you didn't work on it, because it was a ship owned by your employer, and the justice of the situation required it to pay these impoverished people due to all the circumstances that had happened, and that it did fit with the definitions in the section as set out in Section 256, which allowed for context to be taken into consideration. And the legislation had been specifically passed to enable wages to be considered in the disposition of forfeited assets, because otherwise the Crown just proposed basically to give these vessels back to the criminal owners for redemption, which is basically to pay a fine, and then they get their vessels back and can go on running slave ships in other parts of the world. Meanwhile, the Crown have let the ships go on a bond, they say. They don't want to provide us with any information about that. But basically, Oyang has the control of the ships, and they're using the ships, and they're out by Uruguay, fishing away, making money, living their business lives as I normally did, making money. Meanwhile, the crew from the ships remain unpaid, for more than a decade. Well, a decade, because some of the people started working there in 2007. With the most incredibly perverse behaviours, and I'm standing up for it. So I was really grateful to have the wonderful decision of Justice Davidson, who stood up for the crew as well and said that they could make this claim over Oyang 75. Oyang, which is the Sajo Oyang Corporation, they appealed, and it went to the Court of Appeal for a hearing, and the hearing date for that was quite some time ago. We had that on the 8th of September 2016. And the Court of Appeal said they'd get back to us very quickly because they were steeped in the case, was a quote that they said to me at the hearing. And they very promptly, underline score, question mark, turned up with a decision 7 months later, which we didn't think was very prompt. And actually the decision doesn't help us at all, and we're really concerned about it. The decision said that the crew couldn't apply over Oyang 75 because they didn't work on it, and suggested that the vessel could be claimed after it is redeemed by the criminal owners by way of an admiralty litigation for an in-rem claim. Now, how impoverished people who were slaves at sea, who are represented by one lady lawyer here in Auckland, New Zealand, who's a criminal defence lawyer who normally represents drink drivers, but now is up to her eyeballs in admiralty law, employment law and civil litigation, and doing quite well at all that, helping these people so far, is supposed to bring in-rem litigation is just really impossible. The vessels are in Uruguay. You'd have to arrest the vessels in waters around or near Uruguay, bring it into port in Uruguay. You'd have to file litigation in Uruguay to get the arrest warrant for the ship. You would need lawyers admitted in Uruguay to do that. It would be really expensive. Once a port, and then if you did get the arrest warrant, you hop on the ship by flying in your helicopter, maybe landing on the ship and posting your arrest warrant onto the mast, and then ordering the captain into the port. All very exciting, be wonderful, but that would be great if you work for a gigantic big law firm with lots of resources and you're being funded by clients like a big bank who were quite happy to arrest the ship to exercise their mortgages over it. But if your clients can't pay the legal fees, how you're supposed to arrest the ship is just very difficult and impossible really, because also you have to pay the port fees. So port charges can be about $40,000 a month. and I'm aware of other vessels that have been arrested, and $75,000 a month to be paid to also keep the crew going, as well as the fees for the port charges. And you're not talking just a month of the vessel being in port, and as well as being in port, you've got to maintain the vessel, look after it, insure it, and do all those things, and the court's not going to pay for that by itself. That money has to come from somewhere, and it comes from the plaintiffs. But my plaintiffs don't even have 50 cents to pay for their photocopying. So, getting the bank statements to prove they didn't get paid, which is sort of about $8, cost us a fortune because they just didn't have it. So it's something that sets them up for an impossibility. And the Crown, in my view, is implicit in that because they've let the ships go. So that's sort of a factual scenario around why that proposed solution doesn't work. But what we want to do is appeal to the Supreme Court, and we've applied for leave to appeal to the Supreme Court and filed a notice, which I personally delivered to the Supreme Court on the 13th of June 2017. It had to be filed within a certain period of time from the date of the decision. Seeking leave to appeal. It's very difficult to get leave to appeal in the Supreme Court. They have rules about what kind of cases that they will take, and they really have to be in the national interest, I suppose, because they've got to be in the public interest. They've got to have the interest of justice, or they've got to have a substantial commercial interest element to them, which I have tried to argue. But in the cases for leave to appeal, there have only been 2 that were granted leave to appeal on the basis of of the commercial element being such in the public interest. So this is a case involving $1 million of vessels and millions of dollars of wages, and there's 30 of my plaintiffs, but there's more plaintiffs out there as well. And there's more people who haven't been paid, and issues, I suppose, could come up again with forfeited vessels in relation to the foreign fishing vessels. But New Zealand's changed its law also now, so some of these problems will be over for people fishing under the new regulations, but there are still victims under the old regulations. So we really need leave to appeal in the Supreme Court. It needs to have public interest factor, and it needs public support, because we do believe it's in the public interest that these issues be resolved. It's unacceptable, in my view, and it should be in New Zealand's view, to have the slaves at sea unpaid when they could be paid out of a forfeited vessel. The vessel was owned by Sajo Oyang. That was the employer. It was owned by them at the time it was forfeited. So now it's Crown property in the control of the Ministry of Primary Industries. It seems to be like, what would be the harm of selling it to pay the actual victims who were abused at sea their wages? Nothing. Because otherwise what happens to that vessel is it just goes back to the Crown, and they get to keep the windfall of a $9 million vessel, which is probably worth more in New Zealand currency, but that's the valuation. It's $8 million US. Or, they allow a criminal company to redeem it. Some of the fines that have been paid out in past cases are like about $300,000 sort of thing. They might make them pay the court costs, investigation costs, and the fines that the crew the captain and the Korean officers didn't pay when they got sentenced in their absence for their fisheries crimes. I mean, that's another ridiculous examples of the Fisheries Act. They're involved in substantial crimes, enough to get fined $200,000 or more each. And they don't even have to be present because it's a finable on criminal charge. And then these huge fines get awarded, which are meaningless and nothing because they don't even pay $10. There's a $50 offender levy for each person. They don't even pay their $50 levy. We're never going to pay. So I suppose there's some advantage to the public to get that money, but it's money just going into the public purse wherever fine money goes. The same as the drink driver money goes. And you've actually got people here who fished, who were treated so badly, who were raped in the name of getting our hoki. It's shameful, New Zealand. It's so shameful. And I really want the Court of Appeal decision to be overturned, because I think that they were too narrow in how they just considered the issues. They just really focused on a couple of words like "the" in the section, and the whole statutory interpretation became really focused on, minute things. Without considering the whole context which was allowed to be provided for in our submission under the section, because it did have that word in it, but the Court of Appeal didn't agree on that. And we seek for leave to appeal to the Supreme Court, and I'm going to go through the details of the notice for the Supreme Court, but I just wanted to let you know what was going on. And if we get leave to appeal, that will be a really big deal, and then there'll be further submissions. to be filed, first of all to seek the leave to appeal, and then if we do get leave granted, then I will look forward to going to the Supreme Court and arguing it myself, and filing more paperwork and trying to get justice. So New Zealand, are we just going to allow this? And why do people don't care? You know, why? It's an underlying racism in the system. If we're going to say, oh, that's just happened to third world people, didn't really sort of happen to us, well, that's rubbish. We need to do something about it.